The collection of debt has becoming a booming business during the tough economic times of now. However, the increased debt collection has opened up a number of instances of malpractice or unlawful debt collection. In fact, due to these, a lot of innocent people are either incarcerated or put on trial. Reports of unlawful attachment and civil arrests by deputy sheriffs are abound in the media, and the most common reason for this is because people are not aware of their rights and the correct procedure when they're faced with a writ of execution from a court of the law. It is during the course of this process that some individuals find themselves at risk of abuse and unlawful treatment by those who they owe and by those they engage to collect on their behalf. On tonight's show, we speak to Mr. Godfrey Ntomiwa, a registrar and master of the High Court, to unpack the rights and responsibilities of debtors as well as the alleged abuse of power by deputy sheriffs. Later on in the program, we'll be joined by Joseph Kokelezo, a deputy sheriff, to discuss this issue from a deputy sheriff's point of view. I'm Shadi Lindsay, and welcome to First Issues. Harassment of debtors by debt collectors and deputy sheriffs is well documented in our local media and courts. We asked Mr. Godfrey Ntomiwa, Registrar and Master of the High Court, how much of a problem this really is.
Well, I can talk about deputy sheriffs and not debt collectors. This is because legally deputy sheriffs are under my control. They are appointed by me as the sheriff, and they are under my control in the manner in which they do their work. So I can talk authoritatively about those. But with regard to debt collectors, those are under a different arrangement altogether. Yes, indeed. We have had complaints relating to the manner in which debtors are treated by deputy sheriffs, particularly when deputy sheriffs have been asked, I would use the word asked, to recover the debts from them. It is a worrisome situation which obviously must be attended to.
Are there any provisions in the law or rules and regulations that protect debtors or consumers?
You know, a debtor has got rights. The fact that you are a debtor doesn't mean to say that you have lost your rights. No. You still have got as much rights as anybody is. It could be that you find yourself in an unfortunate position that you cannot service your debt. Sometimes not because of your liking, because of circumstances that overwhelmed you and made it impossible for you to pay your debt. Now, if that is the case, we expect you to be treated just like any other person who finds himself in that unfortunate situation. You go through a court process where you either defend your rights or, well, you explain to the court your situation. But if the courts find against you, definitely you must be respected, because the finding of the courts is actually saying the status quo must be restored. By that I mean the debt must be paid, so that the ground is leveled, and once the debt is paid, everything returns to normal. Now, the thing is, the people who are in charge, who are responsible for paying the debt, must approach you not as someone who has committed the most heinous offense, but approach you as someone who has merely failed to pay his debt and then request you to do so. Let's look at the law. What does the law say? The law says in the rules of the High Court, when a deputy sheriff is possessed of a writ of execution, he must approach the judgment debtor and first request for the payment of the debt. That is very critical. If the debtor fails to pay the debt, he must then request him or her to point at disposable movable property. What properties can I attach? Then if he or she points at the properties that can be attached, the deputy sheriff will proceed to attach those property. He must attach property that, in his view, could satisfy the debt is sold. So this is where now he uses his discretion, looking at the amount of money that is owed. If the judgment debtor doesn't have any movable, disposable property or fails to point at some, then the deputy sheriff must search for his or her property. These are the three critical steps that a deputy sheriff must follow. So you do so properly, in a courteous manner, without the need to harass this person. In return, the deputy sheriff expects cooperation, and full cooperation from the judgment debtor, which sometimes is very difficult to get, because some of them would make it so difficult for these court officials to operate. Some would deliberately dodge or make it difficult for the deputy sheriff to trace and find them. Some would lock their premises, their houses, their business premises, and so on. Some would be difficult when confronted by the deputy sheriff. They would not give them a chance or even threaten to harm them. So you meet all these things in the real world of debt collection, if I may put it so.
You've given us the process from the deputy sheriff's point of view. What is the right procedure and process for a creditor to recover money from a debtor? Is there anything that they should do before they approach you for assistance?
In our case, the starting point is a court order. Once you have obtained a court order, then you have got an authority with you to collect your debt. Now, with that authority, you can instruct any deputy sheriff to recover the debt on your behalf. So that is the starting point. So you cannot recover, in our case, without the authority of a court order.
We asked Mr. Antomia, why is it that some deputy sheriffs fail to adhere to the guidelines and the rules that they're supposed to?
We have received complaints that deputy sheriffs take shortcuts. They receive direct instructions from people who are odd. I don't know whether to call them creditors at this point, but it's people who are odd. In our case, you become a judgment creditor once there has been a court order. You become a judgment debtor once there has been a court order. So, but we've had instances where direct instructions are given to the deputy sheriffs, and the deputy sheriffs would either approach the courts on behalf of the creditors, register a case, and then get a judgment, particularly the magistrate court, then proceed. At times we have been told that no, they will just approach the debtors and demand. So these things do happen. But we have been trying to discourage deputy sheriffs from operating as lawyers, because that is not their field. They shouldn't represent or be seen to be representing creditors, because they don't have the authority of the attorneys to do so. So, well, things do happen in the outside world. Sometimes when they reach us, a lot of damage would have occasioned, but we try by all means to deal with such cases and ensure that they are discouraged and never repeated.
We managed to catch up with Joseph Kokelezo, a deputy sheriff, to give us his take on the allegations that deputy sheriffs ill-treat debtors and abuse their powers.
We are officers of the court, and re instructile ke lekgotla la ditsheko re tshotse di warrant tsa kgotlatshekelo. Di deputy sheriff tse di harasa matutotang nkaka, some of our deputy sheriff re ke re kgantse re di utlwang ka ba bangwe ba batlang ba ngongorega mo court gore go na le di-sheriff tse di sa tseng batho sentle, but ra buisana re le di-deputy sheriff gore ba gaetso ga ra tshwanna gore re harass ke ra gore nna myself ke leka go bereka sentle, because at the end of the day re na le register ko high court o e leng gore wa re monitor ebile phoso nngwe le nngwe ko keletso e dirang motho ga na le ngongora go ya ko high court mo ga borona wa ko high court ko lo batse yaanong ke bereka mo ke itse gore tla re ke tshwanetse gore sengwe le sengwe se ke se dirang ke tshwanetse gore ke tsoge ke sa arabela ka moso ga ke tsene ko jarateng ya motho e be ke sa behave sentle ke kukadiwa tsa go ke di latlhalagatse ke sa mo ise sentle o na le tetla ya go complaina ko registera ko high court mme registera wa mpitsa a ba bitsa le ena mongongoregi a ba nna ha be ke botswa dipotso rra ko keletso kana kganki gate ga wa buisa mme ha sentle bile no ira yana le mme ke na le dikgato tse ke di tselwa ke ka mo bonang re na le bona bagolo ba rona ko high court so sengwe le sengwe se re se dira o se dira ka ha molao ebile o se dira o itse re ka moso o tsogo sa arabela ga o sa se dira sentle.
Join us after the break as we continue our discussion with Mr. Ntomiwa on creditors, debtors, and deputy sheriffs. Welcome back to First Issues as we carry on our conversation with Mr. Ntomiwa. Credit providers and collecting agents love to use the garnishee order system because it's the quickest and easiest way to recover the debts. Can you take us through the process?
Takes an application to court for a garnishee order. You are working, you don't want to service your debts, then the creditor can apply to court to have your salary garnished to pay the debt, monthly deductions from your salary. You are a company, you have been given business, and payment is ready. Someone can approach the court, apply that part of the payment be garnished to pay the outstanding debt. That is the simplest way of putting it. You see, garnishee means basically to attach part of your payments to pay the outstanding debts. It could be on a monthly basis, or it could be once-off payment when there's a lump sum of money that is expected to be paid to you.
How can we guard against abuse of the system?
Well, I don't know whether there would be an abuse, because you must prove to the court that indeed the person that you want garnished is owing you, right? And the court, once satisfied that indeed that is so, would make an appropriate order. But you know, it now becomes for government, if it's a company that has been given a job by government to ensure that the money is actually transferred to the judgment creditor, or if it's a public servant, you see, to ensure that, the accountant general would ensure that every month the money is actually paid into the relevant account for the purpose of extinguishing the debt. But otherwise, abuse, I don't know whether there could be abuse of this system.
Is there financial inquiry that can be done to ensure that as they're garnishing from that person's salary, that they have enough to still live on?
I don't know, but when a garnishee is actually ordered, normally it's not ordered in your absence as the judgment debtor. You are called to come and show cause why, you see, and obviously that gives you an opportunity to explain to the court your circumstances, right? And you would be expected to mention the hardships that you are likely to experience when a garnishee is made against you, and that would include, of course, your livelihood, whether the amount that remains would sustain you and your family.
If you've been treated unfairly by a deputy sheriff, what kind of complaint can you lay and to whom?
Like I mentioned at the beginning, deputy sheriffs account to the sheriff. They are appointed by the sheriff under Section 18 of the High Court Act. And obviously, any complaint that one has against a deputy sheriff must be reported to the sheriff as their supervisor. So once you feel aggrieved by the deputy sheriff, report your grievance to him or her. He or she will take it up and ensure that that grievance is dealt with and resolved. It could be a grievance about the type of treatment that you got at the hands of the deputy sheriff at the time of either service of a court documents, execution of a court orders, or you are not happy with the manner in which your property was sold, and then whether any reports were made to you after the sale. Reports would include how much the property raised, whether there was any surplus, what have you, and so on, anything relating to your to the sale and execution. Or it could relate to the handling of your property at the time of attachment, before the sale, the handling of the property, or even the attachment itself, the manner in which it was done. And it could also involve properties that were attached. You may complain that no. I mean, the deputy sheriff attached more than what was necessary for the debt that was owing. Anything that you feel aggrieved about can be reported to the sheriff, and the sheriff would ensure that appropriate action is taken to address that problem.
You spoke about civil imprisonment. What is it supposed to achieve if ultimately the person can't pay that debt?
Civil imprisonment should be one way of forcing a judgment debtor to pay the debt. The courts have said in one case that civil imprisonment should only be ordered against someone who has got the means but who is refusing to pay. So the expectation is that when that person is exposed to those conditions, he will come back to pay the debt. You see? So that is basically the purpose of civil imprisonment. Otherwise, you take a poor person to prison, he comes back poor, and you can't expect him or her to service the debt again.
We also asked Mr. Kwekelezo about some of the challenges that he comes across when he's executing his duties.
Mathata re kopanang le one mo tirong ya rona ke a leng gore go na le batho ba leng gore batho ga ba tshwane. Batho ba bangwe ga o tla o tshotse pampiri ya kgotlatshekelo being a court order or a writ of execution, they understand. Ba bangwe gotlhe ga ba tlhaloganye kore motho la ga go bona o ipega mo ene a ka mola o bua gore ga o tsena go lapella motho wa mo dumedisa o bo mo ipolela gore o mang o bo mo ha ID o bo mo ha yona pampiri ya kgotlatshekelo yo tla beng o tla ka yona go mmegala gore nyaki ke tla ka pampiri e tswang ko court ele ya sekoloto sa gago mme o kolota res mamang bokana ya no rona re tlela go tlo go kopa gore madi ke 12,000 pula a batla go duelwa o mongwe tla ba tlhaloganya bila ba a dumalana le wena gore nyamme o kopa go bua malatsi a mabedi gore a ipakanye o mongwe tlo re halala ntlhantlala ga ema ba lwa a ba omana a ba bua gore di sheriff o di utlwaletse batho wena o heletsa o ntse o ikobile o le ko tlase ga o ilene.
Mr. Kwekelezo went on to share with us what he thinks people don't understand about his job as a deputy sheriff.
So se leng gore batho ga ba se tlhaloganye ke tiro ya rona ke gore ga ke tsore nka ba gore batho ba bangwe especially tota hela ka gore na ke ntse sheriff ya Gaborone le baka batho ba bangwe hela ko ntle le ba bangwe hela mo Gaborone re ka re ba gore bangwe a tlo ipotsa gore motho o tshotse a ntse alo ore kwa tswanteng ga gore ga nna le molao wa Setswana ka rang motho hela ga o tsena hela o tla ba phamoga ba re ke utlweletse di sheriff ga tadina maitseo nna bile motho should go out of my house o bo lwena hela o moleba gore o le ka gore o mmuisetse go tlase gore monga me ga ra tla ka tseo re tle yana le yana ba bangwe hela ga o tsena malapeng o ka go amogela ga ngwe o bo rapele modimo gore kare motho o ne o tswa ko wena ko phase 4 o ka tshwana le batho ba bangwe around town because o tla ba go tsaya sentle a be ebile a kgona gore a founele lawyer a gagwe a kope more advice gore ame with the deputy sheriff me wa touch lawyer a go e be kgone o bua le wena o le kokeletso gore nya re kokeletso do your job then come and see me on behalf of my client ba bangwe ba alwa my sister I have to be honest with you mo heleletsa ebile o ile ko high court o tso kopa a memorandum ko go registera gore a go thusa.
We're now going to share with you business and finance news that made headlines this week. We hope that from tonight's show, you have learned the ins and outs of your rights and responsibilities as a debtor. So whenever the next time, if ever, you're faced with a deputy sheriff, you know exactly what to do. I'm Shadi Linswe, and have yourself a good night.